Hey, 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 it's Thursday, January 18th, 2024. One more day till the end of the week. Today, guys, we're following the Delphi hearing for Richard Allen. Thank you all for joining us. It should be quite an interesting day, guys. So thank you all for being here, and let's get this show on the road. What up, what up? How's everybody doing today? Thank you all for joining us today for this huge day. Hopefully, things go the way they're supposed to go. The hearing in Delphi for Richard Allen to have Judge Gull taken off the case, off the bench for this case, and to get his attorneys back, his defense attorneys back, his original ones back, I should say. So hopefully things go well for him, and then he can um, get what I feel would be more chance to a fair trial. And again, as we saw the other day when I covered it, they moved him to another prison, and he's just in just as bad a shape there as he was in the first place. So now they motioned for him to be put back into a county jail so that they can actually, help him, because they haven't been able to do that. So thank you guys all for joining us today. The trial, or the hearing itself, was at 11 a.m. In Indiana, there, Delphi, there. Well, through the Supreme Court, I should say. So it's gonna be. I'm sure it's not gonna be live streamed immediately afterwards, which is why I waited till noon to go live. I checked it; there was nothing live from 11, so it was gonna have to wait anyway. So let's see who has joined us today for this. Give me one moment, folks. All right, guys. Sorry, my wife's vacuuming. Having a white dog is fun when you have blue carpet. It's interesting. But anyway, it looks like Victoria is in the house. Welcome back to you, Victoria. The Riddler, welcome. Good to see you, brother. Sweet Surrender. Miss Katie, good to see you. One Made Nut. Eddie is in the house. What's going on, brother? Good to see you today. Miss Sunshine, good to see you here. Thank you for joining us today. Miss Kells is in the house. What's going on? Kate Pruitt, good to see you. Good to have you here. Deborah, good to have you back. Great to see you. Miss Brandy B, always happy to have you here. Carolyn Miller, welcome back to you. Tina B, to you as well. Knowledge is power. Hello to you. How are you today? Good to see you. Kate Pruitt, thank you for joining us. Great to have you here. Sarah D. Irish, welcome back to you. Good to see you. North Carolina Mountain Man, great to have you here. Great to see you. Thank you for joining us, brother. Sandy Kerf, welcome back to you. Dakota Parker, always a pleasure. Sony's in the house. What's going on? Jody Walters, great to see you as well. Let me see. Nat Cat, welcome back to you. Doodlebug's in the house. What's going on, Doodle? Good to see you, dear. Thank you for being here. Miss Deborah, again, if I already said it, sorry, but great to see you. Thank you to the moderators for joining me today. I do appreciate everything you do. God bless. And I love you all so very much. I will say, once again, somebody just stated that it's live now, so I'll be going to that here just in a second. I'm going to ask this again. Anybody that comes in here, please, I'm asking you to please respect our moderators as much as you would respect me. I am an extension of them. Everything they say and do, I appreciate you respecting them as if you would respect me. I'm going to say again, my apologies to anybody that was offended yesterday by anybody else in here. I've looked into situations and handled it the best way I can. Okay, and then hello, Clue. Welcome. Cletus. And Clue says, hey, all my apologies to anyone who she may have offended last night. But like I state very transparently, I'm not for everyone. Okay, thank you for that. I do very much appreciate that. And for anybody else that's in here that was possibly offended by her, thank you for taking that. And thank you, Clue, for that as well. Zelda, welcome. Good to see you. Michelle Apple, good to see you. Good to have you here. Thank you for joining us today. I appreciate you very, very much. Hold on a minute, folks. I got to pull this up now. I don't want to miss too much of anything. Thank you for that update, Kels. Hold on. Where's it at? Oops. My mistake. There we go. I had the wrong number. Where is it? Come on now. You told me it was going to be here. Hold on a second, guys. Here we go.
Richard Allen, relator versus
Green Sword. This is the big stuff, folks. This is not a joke.
Respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus.
There's an echo in there.
Representing the relator.
Welcome, Glass Boss. And Walt Harris, good to see ya. Guys, on your way in the door, please hit the like button if you will. Appreciate you very much.
Good morning, Ms. Winnicky and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, council table, we have Angelo Sanchez.
We'll figure it out, Kels, I promise.
Welcome. You'll be arguing
Deborah
first.
Thompson, good to see you.
Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first.
Why
And
is the
counsel table, we
echo
also
going?
have Chris Stake, who's also here on behalf of the respondent. Correct. Good morning and welcome, Mr. Stake and counsel. Counsels, we've been conducting oral arguments. You'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. So you ready to proceed?
That's on their end of things. They need to fix that.
Mr. Lehman.
Brandy, can you help her to update her info on that, hon? Because I'm not sure how to do it, and I can't at this moment do it. Damn. Interesting.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case
It's
over the
echoing
client's
through
objection.
there.
The lawyer is licensed in the jurisdiction
man.
and
They have
prepared
the
for trial
echo.
on the
I'm sure
scheduled
it's double echoing through
When a
me.
judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates
I'm
the
muted
court
now.
intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review, distancing the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes, and his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an actor.
Gonna make the judge mad already.
When the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of the court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these
Okay,
circumstances.
so, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons. If they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion that the trial court judge has.
There's an absolute duty to follow the client's wishes. And then when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary
And
decision.
the absolute duty is found under the Sixth
So
Amendment.
good to see you, Nellie.
Judge, I
Thank you for
think the
being here
absolute
today. I
duty
hope you're
just
doing
under this court's
wonderful.
case
We've
law,
missed
but I
you.
think that in the aggregate, that the three violations of the Sixth Amendment provide this, constitutes three situations where in their totality, they clearly place the limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record that had preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that.
You have a lot of concerns, but I've got a couple, you've got a lot of concerns and you do a nice job laying those out in your brief, but there's a couple things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to to grant something that wasn't requested at the trial level?
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge.
Just so you guys know, the echo that's coming through is on their end.
So
Yeah,
they
from
sat
blowing
on
out
it
their
for
microphone.
They had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor, they had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that
No,
were going
Richard
on,
Allen is not
was to
here
present
at this
that to the
hearing at
court and
all,
make
which
sure
I
that
think
this
is a
court
little
had an
odd. I think
opportunity
it should be
rule on
able to
it
be,
if
but
it
he's
wanted
not.
to do
Does
so.
your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues
But
don't
maybe
involve.
if there's not a record, maybe then the findings aren't proper.
This is gonna be
If the findings are
interesting,
correct, why doesn't what she did follow from those findings?
Because the client has the autonomy
Good
to
point,
choose
Alex.
the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has
Waive
developed
what concern?
relationships.
Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regard to disclosure of the Westerman's material. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride
I'm
with
just asking you
these
to tell us
lawyers.
on the record whether that's something you're
This is gonna be
asserting on your
bad,
client's
folks.
behalf.
I
If
can
we
just
grant the
see
relief
it
you
now.
want, there will be no Strickland claim that can be
Any
asserted
ruler,
because you're
hold on to
waiving.
you.
I think on the West, if the judge was to build appropriate record, that can happen. The judge-
SRB,
that's
welcome,
what
dear.
happens
Good
in
to
all
see you.
conflict
Yeah,
of
this is
interest
heated
cases.
already,
That's what
guys.
happens
It's
under the
gonna
court's
be
case
bad.
law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the
Thank you,
wife, he's
SRB.
representing you, or excuse me, he's representing your husband, ma'am, and he's
you,
representing you.
Doodle.
Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interest, his loyalties are
Exactly,
divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to
Poor
invoke
guy.
a
He's gonna be
Strickland
drinking tonight.
argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive
Thank you, Kel.
certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counselor, we're not talking about waiving conflicts of interest. We're talking about waiving.
No lie, bro.
ineffectiveness.
I didn't think it was
None
gonna be
of
this
these
heated
things
this
that the
fast.
judge is citing have anything to do with ineffectiveness of
Mama
trial counsel at
Bear.
trial. Ineffectiveness is
Dear,
not
thank you for joining us.
coextensive with ethical violations.
She thought his representation was grossly negligent and incompetent.
She said you're grossly negligent and
The lawyers-
incompetent. I don't know if it was about trial representation at all. And then the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge just, there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really.
I
what
want to
was,
hope so, Carolyn.
Our original jurisdiction.
Welcome, Vic.
is
Good evening to
very
you.
limited.
Good to see you tonight. Thank
So,
you.
If we were to agree with you on the substantive arguments that you've made, why is it that the regular
I can
appellate
agree,
process
Sunshine.
is wholly inadequate?
Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, because she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Baldwin and Rosie, who he'd been working with for over a year to develop and get ready to get that prosecutor on their back foot with a well-developed third-party guilt strategy that was
Welcome,
going
Lisa
now.
and Noli. Good to have you here today.
We would have
Josie
a
West
record
as
if
well.
they hadn't agreed to withdraw.
Come on in, guys. Hit that like
Gone
button on your way
hearing.
through the door, please.
I don't think we would have had a full record even then, Judge. The judge was saying that there wasn't.
I hope
it was
so,
the
Riddler. I mean,
coercive
it's kind of
action of
hot
the
right
judge.
now.
I'm
We'll
going to
see.
go out there and I'm going to say these things, and Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more, because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Got
those
a hearing.
positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the
So
60
my
minutes
concern is getting
require.
this case back on track. All
Yes.
right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error, it'd be reversed, and everybody would have to go through this again, correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off
A
the case.
lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland effective assistance of counsel and say, Mike, my attorneys were not affected. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any
Yeah, I
sense.
know. It sucks, guys. The echo is coming from their end. Their mic set up is screwed up. That's why it's echo, and I've done everything I can.
Will
to fix it.
eventually
Not
fall
me.
into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case. Excuse me, the lawyer will eventually himself
Welcome,
pull out a
Brute.
case or a
Mama
conflict of
4.
interest will
Good to
develop.
see you.
And we see that in some of the other cases across the country. And so like if a lawyer in one case was obstructing justice, was literally going behind the scenes, talking to co-defendants who are represented, trying to manipulate their testimony. The judge at that point just proceeds forward the law on conflict of interest. It says, calls forward those
Welcome,
witnesses.
Jesse Land.
Did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, other than that one rare exception.
And I'm still a little confused with the exchange with Justice.
I agree,
Slaughter
Nelly.
about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through
I don't know
PCR
what you mean,
post-conviction
Noel.
relief proceedings a claim that his counsel were ineffective?
Welcome,
for the very same
Rowena.
reasons
Nothing
the trial
yet.
judge here found?
So the trial judge here found that.
What do you mean by that, Noel?
It depends on what record the court would build regarding those. No, I'm going to change that, Justice. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago and in direct response to press that the government was putting out, I don't see how those issues.
Oh, okay.
affect his
Yeah,
trial.
that's
So
what I
don't think
figured,
he gets
Noel.
post-conviction relief through that because those issues don't affect trial strategy.
But you're saying it would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial.
I'm not
publicity
sure,
and
Noel. It's a
somehow
good question, though.
establish that
I'll have to
might
look into
be
that. Thank you for
affecting
asking
his
that.
trial and that fully and fairly advise him, that's a repercussion. But if when he's fully and
Welcome,
fairly
War Eagle.
advised of that, the repercussions. of
Roll
that,
Tide, roll.
Judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So
Well,
yes.
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
No, that's not
This
Rozzy.
record does not support ineffective assistance to counsel.
But even if it did,
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that a law that would constitute ineffective assistance to counsel for a Sixth Amendment violation. So
Good
if
point,
we were
Robert.
to get
Thank
to
you for
that
that.
point,
Welcome, Sooner
and he
Girl.
was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did have nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, and goes into the chambers and said, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of ethical rules, that there's a disciplinary proceedings that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance to counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case. it'd be a conflict.
Absolutely,
So
Nelly.
we're
Absolutely.
struggling to
There's
find
a
a
lot going on
situation
with that.
where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant can it?
Welcome,
says, I want to
Philip
move forward, I'm fully
Hughes.
and fairly advised of it, and the judge somehow
you're
has
doing
a
well at
absence of
dialysis
conflict
today,
of interest
sir.
injecting herself.
Thank you so much for tuning in.
And I
Much
do think that you
appreciated.
can waive, you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples, these are good examples of that. And that the inadvertent disclosure of pretrial discovery would have
Good point, mountain man.
the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for the counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to
No, I think if there's a concern, say, for example, the pretrial publicity, the press release, if you say, listen, I think because the violation says it has to affect a fair trial. So, okay, you're going to have the hearing, the judge can have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel, Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and the case goes back to trial with a different set of lawyers that this defendant does not want, that there is built into that record at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt. The public's going to be hurt. The entire Indiana judiciary is going to be harmed because this trial has been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and get
probably because they're Supreme Court judges, and they have the ability to do that.
Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days, and that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved claims such as those that Mr. Allen raises here to the ordinary appellate process. And third, on the merits, In removing Mr. Allen's counsel, the trial court did not abuse the court's discretion.
Don't
The
start
trial
talking
court has
about the donut,
significant
folks.
latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on?
Makes
We
sense.
don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that two different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers, but
It's
hard
not
to look
that.
at this
It's the
record
fact
and not,
that he's not comfortable with it. I
get the
mean,
impression
comfortable
that
with the
perhaps
other.
rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
counsel.
struggling with that. Butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave press release.
I
Well,
agree,
the gag
Eagle.
order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record
wish,
now,
Eagle, I
take
really
notice,
wish.
there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing, we don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief
What's
Justice
up, bro?
Shepherd
Good to
in
see
the
ya.
Knox case
Roll
saying
Tide.
a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite.
Yeah, the echo is on their
Under
side,
Wheat,
really. I tried. It's not
The
me.
trial court's
I got
discretion,
the way their
when
mics are set up
faced
is
with
all
the
screwed up.
balance
Sorry about that,
between,
brother.
on the
Thank you
one
for being
hand,
here, though. I appreciate this.
counsel's right to select
Appreciate you
counsel,
being here
and
for
on
this.
the other hand, counsel's right to effective assistance of counsel. What Wheat says
Thank you.
is the trial
Or
court is to
Eagle.
be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed
Welcome, Silence
must
No
be
More.
primarily resting.
And I don't read Wheat, and I look at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against constitutional
Same here,
protection,
Jiggle.
and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us
Be
to
nice
address the
now.
merits. I mean, I realize you think there was no mistake, so why not ask us to just say that?
Crimson Tide
And you're certainly right that we have plenty
Auburn
of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other? whether this was error.
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even ask for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So you're
Also, you think that counsel's, Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective?
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can be any serious question that these kinds of claims for Sixth Amendment violations of the right to select counsel are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so
violation.
I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done. There's a way that you do it. And it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of
So
procedure.
there's no process involved at all for taking no hearing? No, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and draft a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of these actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
I do know, because she said then at the hearing on the 31st, what's changed. So, which means.
Well, we won't know what would have happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel capable of making?
I keep getting back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of word out there, but let him have his attorney. They get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with a lot of different people playing, in the Wheat case. I don't think Wheat is tucked as neatly as you find Wheat. So go outside Wheat and give me something else.
Well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But where can you point to me saying, with regard to saying somebody is incompetent or negligent? We have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, is certainly not consistent with the norms of the profession, to negligently and
Welcome, B.
repeatedly
We've missed you.
allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in a letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to disqualification of counsel on either side. I think your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause a significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise a speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold traditionally precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm?
The echoes on their side, JT.
Go do it the right way. I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel, we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps we don't know, but let me offer
Wouldn't that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was moving counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly, on this record, has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you, Mr. Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen's counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself. What
would be the harm if because of the necessary delays in backing up and going back through again, reinstate counsel, and if the judge is correct, then that will weed itself out. There'll be a hearing, and it'll be done a proper way in the trial court, and then come back up.
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will be.
Do you agree that with under U.S. Supreme Court precedents, Gonzalez, if there's a mistake made in the defendant's case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there. If someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we can we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule, something like
weighted.
it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to the all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at, if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where in one of those incidents in itself might not.
But there's no other case out there where a judge sua sponte on her own motion disqualified Stan for finding her for believing incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even
but for these reasons, it could be conflict, it could be
the wording the judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance in counsel cases, and so forth. But it's not the typical language.
Just so I'm clear, you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing it. Despite that, the state's going to double down and say no relief today. Is that right?
No, we don't think it's a writ. There's no order. There's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just is prevented from doing so even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see my time's up.
State by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions or motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? We don't know. All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Gull, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have the letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what our ethical rules require them to do, which is to give you zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure of justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of discovery order is something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants to say here. Justice Masson, Justice Gull, and Justice Slaughter, you'd ask a question about ineffective assistance to counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance to counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance to counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance to counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client, trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance to counsel, or would even, if proved to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise to ineffective assistance to counsel, justices, I'm not conceding that, but if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than for the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument.
No, so it just cuts out completely?
The case.
Come on.
Decision as quickly as
Are you
possible.
kidding me? Oh, they're recessing, so they cut the volume quickly. This is crazy. This is the worst sound I've had at this point.
Obviously, the people on that side of the room are not talking about the Constitution. So they are throwing out 200 years of precedent. They're ignoring the...
Hang on, guys. I'm trying to...
We're here this morning to argue in the case of State.
What's going on with the damn sound on
Richard
there?
Allen, Relator versus Carroll Circuit Court and the Honorable Fran.
Are they recessed or are they coming back again?
Counsel for Richard Allen, the Relator, will argue first. We're hearing.
Are they done
case,
completely?
Writ for mandamus in a prohibition case. Representing the Relator today, we have Mark Lehman. Good
Yeah,
morning.
we're not going to get a
Mr.
ruling
Lehman
today.
will be arguing the case. At council table, we also have Carol Winnicky.
Well,
Ms.
guys,
Winnicky,
I mean...
Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct?
I don't know if anybody else has got this or not.
Second.
I guess they're done. I didn't get to hear the very end of what he said because the sound, whoever was filming it, turned the sound off. All right. Hold on a minute here. I want to hear what Sarge and Willie, I want to hear what you guys have to say. So there's a link. Come on up here and let's talk about it, Sarge, Willie, anybody that wants to talk about it. Come on. Curious to your guys' opinions on this and what your thoughts are, and I'll give you mine as well. Yeah, that was the only live feed that I could find other than somebody else having it, Carolyn. I think they're done though. What's happening?
Well, what? Hang on, let me turn off the YouTube stream. Let me turn the volume down so I don't ruin it.
Yes,
Shit.
hey.
Okay.
Yeah, I want your theory or your opinions and thoughts on this now that we've seen it.
I think when I watch these, what I'm looking for is for the state or government to provide case law to the court that irrefutably solidifies their position. And I don't see that in their argument.
Right.
Okay. So what often will happen is, and you'll see the defense will argue their argument, right? And the court will focus on that. Oftentimes when you see the court questioning, we'll call them the government, and their questions look favorable to the defendant, you have to keep in mind that what the court's requesting is for the state or the government to explain and support their position with case law.
Right.
And that's why it looks like when they're questioning the prosecution in this case that they're in favor of the defendant. You know, because it looks very favorable as you watch it to the defendant. And that may be the outcome here, but you can't base your outcome on the questions that they're asking because there is something they're looking for.
Right. Right. Agreed.
Right. They could very well come out and deny Mr. Allen that counsel. That's still a high, that's 50-50 at this point.
I mean, I think that this guy here, I think he did well personally. Most of what he said, but I think he was nervous. I'll be honest with you. Supreme Court judges are kind of hotheads. You know what I mean? In my opinion,
so, you mean this guy standing at the podium?
Yeah, I think he's the only one that spoke for Allen and his
of the ones that I've heard. He was the only one that came fully prepared to address the arguments placed against the defendant.
Exactly.
There was no stuttering. He was very clear, and the case law that the state is trying to get the court to interpret broadly across Mr. Allen's case,
right?
He destroys that when he tells you that's case law based on a conflict of interest, and this isn't a conflict of interest case.
Right.
So that's what I mean when they're demanding case law be provided by the government to support the government's actions. And in this case, it appears to me that there was no supporting law or case law on the books.
Right.
I think Allen wins here.
I agree. I do. I think that they did well, and I think he's going to get what he needs, what he wants. I feel good about this. Now, the other person on the other side that was defending the judge, in my opinion, was a joke. Sorry, it didn't. She had no idea. Like the one guy, and then that woman didn't seem to know what she was talking about either. So I don't know. Take care, Nelly. Thank you for joining us. And where'd that go? I just saw somebody that said, now, where did you see this at, Tomboy? 30 minutes before the hearing, they dropped the red rum charges against Richard Allen. What? And where did you see that? Because if that's the case, I want to see that.
What's red rum? Is that the entire case?
It's murder back, people don't like to say it.
Yeah, we're being trained to call it something polite like unalived. We want to make this act comfortable for people's ears.
That's YouTube for you. Hold on a minute.
Unbelievable.
Bob Motto, Defense Diary said this. Hold on a minute. Let's see here.
If Bob is out, I will gladly come on. This was fun. I love doing this with you. And yeah, guys, make
1 second, guys. Well, that's Jay. Was it Bob? Oh, okay. All right. I just wanted to make sure. I about fell out of my chair. I was like, what the hell? Okay.
That's not accurate, correct? They did not dismiss this case?
Not the charges weren't dropped. That's what everybody else in the chat said. No, but
yeah,
I don't know. That was
one little stray comment comes in and changes the whole dynamic of what we're looking at.
Well, hold on.
Adelson.
Charged with kidnapping and not, first degree murder. So, that
Luthi, where'd you oh wait, that's Mandy Ray, not sorry.
Hold on.
I guess that's something on the docket already. And a lot of you might not already know that he's only charged with kidnapping and not, first degree murder. So, I find it very, very, very convenient and odd and strange that he would decide to do that today, although Dizzy says there's nothing on the docket. But some things, if you're, I don't know if Mandy's an Indiana lawyer, like Bob knows everybody. And I don't know, I know Jay, you know a lot of the people on here as well. If she's seeing something that Dizzy just hasn't seen yet.
It looks like Sleuthy posted it.
Sleuthy.
Maybe I might be able to get that right now. Hold on, let's see.
Sleuthy posted it on Twitter. Well, shit. Congrats, B, and welcome back to
amended pleading filed information.
Hold on, folks. Let's see what this
Stamped. Motion for leave to amend. That was just.
This is Bob's wife.
Wow.
Yeah, there it is. All right, let me pull it up. I think I can pull it up here.
Let's see. This is Jay, by the way. I love both of these guys, and Bob as well. They're amazing. Bob's probably.
There's also a large amount of discovery that dropped today in the Westerman's case. Oh, that's all Jay right there. They're like, hey guys, here's other work for you. There's these other things happening. Motion for leave. Yeah, keep going. Well, yeah, what time does it say up there? Sorry.
10:30 a.m.
Wow. So are you kidding me? Is that the same time? Wait, no, the judge they started at, I was supposed to be on at 10:30 their time. So
they started at 11 their time, right? So that would be
right. So he did it literally
a half hour before
the Supreme Court. State filed charges. Defendant was arrested. A detective with Carroll County Sheriff Department. Probable cause affidavit executed by these detectives.
Sorry, I'll stop.
No, that's right. Identifies acts of murder. Okay. The discovery in this cause also revolves around acts of murder.
Thank you so much, B.
Charging instrument.
I can read. So the charging information, the probable cause in this matter reflect the charge of murder, commonly referred to as felony murder, specifically that Richard Allen did kidnap victim 1 and victim 2 by force, and in the process of committing that felony, both victim 1 and victim 2 were murdered. The state hereby moves to amend charging information to add additional counts, which include murder for both victim 1 and 2 along, and then I guess that's probably get the next page.
Well, yeah, so he does that right before the Supreme Court's going to rule. I mean, it's just the kind of things that just make you say, like, does anyone, care about the truth? He's like, okay, just in case anybody, thinks these guys should get the lawyers they want, I want to make 100% clear, in case you didn't already know, that these 2 beautiful children were deceased, that, now he's charged with.
What happened was he was only charged with kidnapping initially.
Yeah.
And
but where's the dismissal? Didn't somebody post that it was dismissed or removed?
No, somebody said that the charges were, the murder charge was dismissed, is what she thought. But what it was that
they were added.
It was just backwards. That's all. He was only
charged. It was backwards. We were going backwards like that Reed woman.
Yeah. He was only charged with kidnapping initially, and now they added this charge. This is a joke. They added this charge half hour before the Supreme Court goes into effect. I mean,
Supreme Court,
to make sure
that won't have anything to do with the Supreme
She didn't
Court.
say dismissal. She said, hold on a minute. Let me go backwards and get that comment just to be sure.
But it sounded like she said the case was removed or something.
That's what I'm going back to double check it.
Right.
Hold on.
I mean, it's I could be completely wrong. If so, I apologize.
No, it's okay. I mean, everybody makes mistakes. No big deal. Let me find it. Okay. 30 minutes before the hearing, they dropped the red rum charges against meaning they dropped the charges on him, not dropped it as in dropped it, because he wasn't charged with murder before. They dropped those charges on him. That's right. He was only charged with kidnapping, so no worries.
Okay, against but that statement don't make it read as if there were.
Yeah, I know.
They dropped the charges against RA.
That's what I thought too, and I forgot that he had
Yeah. The context was drawn incorrectly because of the word against.
Right. No
They could have used the
problem.
word on RA instead of against RA.
Yeah, no problems, Tomboy. It's okay. It's
our
okay.
misunderstanding in the way we interpreted the way it was written. No big deal.
She said, "I'm sorry. Thank you. I guess I missed a word there. No problem. It happens."
No, it's okay. But it is funny how one word, and this is not an attack on anybody, but how one word can change the dynamic of an entire sentence.
Yeah.
Right?
Just the letter A completely, or the word the. Everybody was like, "Whoa, wait a minute."
And if you're from Canada, you do say a quite a bit. It's very confusing.
So what happened here, guys, is the state decided to drop these extra charges on him. On top. Are you sure about that, Teresa? I may be missing. I don't want to
day one.
I want to make sure I'm clear on this. Let me go back. The way they're explaining it is that they added these charges and that it wasn't
Deceasing them.
It's wild. This is.
I need to find Sleuthie. Hold on a minute. I'll pull it up. Yes, sir. Take your time. Let me find this, guys, for you guys real quick here. Let's get this pulled up. I need to find the document is what I need to find. Hold on a minute. Let me see if I can pull this up. He was just read his first paragraph, deceasing what he was in prison for kidnapping charge. That's what I'm looking for, CL. Hold on a minute. I got to clarify this to make sure everything's right. No worries. No worries. Hold on. Let's see here. All right, let me see here. So it looks like that the charges were amended is what it was. Okay. Comes now. Here, I'll just read the document to you guys. This was filed today at 10:30 a.m. I gotta blow this up somehow. Maybe not. Comes now the state of Indiana by prosecuting attorney Nicholas C. McClellan, and hereby respectfully ask the court for leave to amend the charging information filed in this case, in this cause, on October 28th, 2022, and in support, therefore, does affirm. On October 28th of 2022, the state filed a charging information alleging these offenses: murder as outlined in court count 1 and murder as outlined in count 2. The defendant was arrested on October 26th by a detective at the Carroll County Sheriff's Department. The probable cause affidavit executed by the detective, now Sheriff Tony Liggett, and filed by the state on October 28th, 2022, identifies acts of murder on or about February 13th of 2017. The discovery in this cause also revolves around acts of murder occurring in Carroll County on that date. The charging information and the probable cause in this matter reflect the charge of murder under IC 3542.112, commonly referred to as felony murder. Specifically, that Richard Allen did kidnap victim 1 and 2 by force, and in the process of committing that felony, both victim 1 and victim 2 were murdered. The state hereby moves to amend. That's what this is, guys. It's an amendment to amend the charging information to add additional counts, which include murder under IC 35-42.1.1 and 1 for both victim 1 and victim 2, along with kidnapping under I.C 35-42, 3-2, and IC 354232 B2A for both victim 1 and victim 2. The state is asking the court for leave to file these amended charges because the charges more accurately aligns the charging information with the causes discovery and probable affidavit. Because of the clarity of the discovery and probable cause affidavit, the defendant has been on notice since the beginning of this case that this amendment does not prejudice the defendant's substantial rights, that the trial for this matter is 9 months away, giving defense adequate time to prepare to defend the amended charges, that this amendment does not substantially change the state's theory of the case, and wherefore now comes the state of Indiana by prosecuting attorney Nicholas McClellan and praise the court to grant the state leave to amend the charging information filed in this case on October 28th, 2022, and for all other just and proper reliefs in premises. Signed by attorney McClellan. Wow. That is sneaky, folks. So what they did was they amended the charges, okay? He was charged with kidnapping as where, and in the process of committing the felony of kidnapping, victims 1 and 2 were murdered. They went in and straight charged him with murder is what they did, okay? This is insane. Exactly. That's Teresa, right.
I think in the context of this case, it's a bit effed up, but
it's
not an unusual thing to happen.
No. But I'm 30 minutes before the Supreme Court hearing, they knew what they were doing. That's sneaky as hell. Take care, Robert.
I don't know how that. I don't think that it has anything at all to do with the argument in front of that court, or it'll have any impact or influence on it at all.
Well, why would they wait to 30 minutes before this hearing's happening to do it, though, Sarge?
Well, you had Holiday, Martin Luther King, and then they want the attention drawn to them, and they don't want people paying attention to the court. There's always that, right?
Yeah, I agree, but there's so much that's stacked against him at this point. I think they were afraid that if it looks to me, at least, I should say, that they were afraid that if they were to grant this, that they were going to look into the possibility of trying to have a dismissal put into motion. Okay. So
It may also be a move for the attorneys that he's trying to retain that just aren't capable or aren't skilled to do a death penalty case or a murder case. I don't know what the level of these attorneys are.
The Rosie and the other attorney, I always forget his name. They were pretty good, and I think that they have his best interest at heart. They were willing to do this pro bono. Period. And the judge said, no, I don't want you doing this because of what had happened. That scenario you asked about.
Like, as an example, in the state of Idaho, there's only a dozen those free lawyers for the defendant there, but there's only a dozen of them that are murder qualified.
Right, and they never talked about
this may be a way for the system to be trying to screw Allen again by pushing this up to a murder charge, which may be too deep a water for the counsel he's demanding to keep.
Yes, I see what you're saying.
Right? You see what I'm saying? So in that sense, it could be a sneaky ass move to give the judge what the judge wants, which is those lawyers gone.
Yep. And they're trying to recuse Judge Gull from this as well. So in that point, this is sneaky. And now they haven't spoken about death penalty at this point yet, have they? I don't remember hearing death penalty.
Not to my knowledge, because it was a rape case. But I just want people to know in the room that you have a traffic lawyer and a real estate lawyer. You have a criminal lawyer. Lawyers generally are specifically designed to handle a field of law, not all law.
There was no sexual assault in this, by the way, Sarge. Not that it was listed.
I meant kidnapping. If I said rape, I completely missed.
That's okay. No, it's okay. I got you.
Yep. But in the skills of your attorneys, this charge being added may be too deep a water for the attorneys that he's arguing he should be able to keep. Right. That doesn't mean that this isn't going to be adjudicated, and I suspect to be adjudicated in his behalf, because remember, I've said before, the purpose of a court judge is to protect you from government overreach.
Right.
That's the only reason they exist. The word judge I think is a bad word, and when it comes to what they're supposed to be doing, and often the judges clearly don't do that. But
Right.
that's their only reason to exist is to make sure that the action brought against you by the government does not go against the constitutional limits placed on government.
Exactly.
Kind of convoluted.
Here's the thing, though. CL has a good point, but they need new evidence to be presented to the court for any amended charges. I would think, isn't that true?
We don't know that they don't have it.
Well, that's what I'm saying. If they have it, where is it? Don't they have to present that to the court to be able to amend the charges?
I'm not so sure that they can extrapolate being the last person in contact with them through to a kidnapping that they're whatever word YouTube wants you to use today is also part of that crime.
Yeah. No, I got you.
I don't see how they could be prevented from doing that.
This is an interesting scenario here because I didn't expect this. Teresa says, in my opinion, his former attorneys were too close to the truth. A lot of people have said that, Teresa, that they were getting really close to something and all this shit happened. So it can be seen that way. Or it just could be that,
I sadly didn't follow that case. That hearing that you played today is the most. And then I heard another little one where the lawyers argued against the judge on that tape, right?
Yeah.
I've seen that and then today. So unfortunately,
it's
how did they charge him with kidnapping? Under what basis? What evidence?
Based on the fact that they were taken from the area that they were in to another place, supposedly. And
what ties him to that? What evidence? Is there DNA? Is there
the bridge guy and the bullet that they found? And there's not a lot. That's what the problem with this is. Everybody says that Kohberger's situation's bad, but it's not. This is way worse compared to that.
Right.
They have nothing in this, honestly, Sarge. They have a bullet that fit a gun that he owns that was it wasn't discharged. The bullet hadn't been used or fired out of the gun.
Okay.
It was just, but it matched up to the gun that he owns, which
so if it was a 22, we all own 22. So what does that mean? Right?
That's pretty much it. Same scenario. It had a very weak PCA. That's true, Teresa. There's nothing. So basically, the charge he was charged with was the fact that the two girls passed away during the kidnapping. So that's how it was charged initially. They turned around and now they're charging him as if Richard Allen himself, is the one that committed the murders. So that's the other one too. He did confess to this over the jail phone to his wife and his mother, but everybody at this point does now believe that it was a coerced confession. Richard Allen himself brought it out and stated that this was done in an Odinistic fashion by Odinites. Okay. So then he is arrested, and within 24 hours, I believe, or maybe 3 days it was, don't get me right, or don't quote me yet. He was transferred to a prison, not county jail, to a prison, they said, for his own safety. And it turned out in the document that it was basically for everybody else's own safety that was involved in this. So then he's in this prison, and the COs there are wearing Odinist patches on their body, on their uniforms. Okay. That's a problem. So then he refuses to eat, which I don't blame him because I wouldn't trust the food either. It was stated by another inmate that did a testimony that he's been being abused. Tasered, just things like that, a whole bunch of type of abuse. And you saw the guy, he looks like The Walking Dead. And I do believe, and then it was admitted that he was drugged. He's been handed multiple different types of medications to take. He's never seen a doctor. That's not normal. And he was basically being abused. You're right, Jesse, being abused daily by the COs and stuff like that. So they take him and they get a motion to move him to another prison. They do that. He moves into a worse situation now. Okay. There's actually guards there that have tattoos on their body of the Odinistic markings and stuff like that. And everything this happened in the last prison too. Every time his lawyers would meet with him, this man never had any privacy at all. They were filming him constantly, watching him constantly. and it's way further away than what it was. But every time his attorneys would show up, there was a guard standing there filming this. I mean, none of this is legal. Okay. Then the judge basically takes his defense team and just throws them away. She blackmailed them into recusing themselves, and then comes out to the bench and acts like it was a big surprise to her. This thing has just been a joke, Sarge. The whole thing is a joke.
Yeah. That's so consistent in so many cases that come across these streams on YouTube and gets lost upon the media, and that the procedures, the policies, and the actions of those we entrust to enforce the laws are often conflicting with what their job detail really is.
Gotcha.
Right.
Yeah. Right.
It's sad. It's where was I? I was watching another stream, parts of it. I've been busy the last few days, but they were bringing up that horrible word corruption, and corruption is it's an endemic thing. It's throughout the system, and even good people don't realize that the way they're making decisions out in the field are not correct procedure.
Absolutely.
You know?
Agree.
And but they don't know any better, simply because that's the way they're exposed to understand their job.
Yes, sir. And see, this is how he looked when he was arrested. Okay, healthy, so on and so forth.
Yep, a little thick there in the face.
Yeah, I mean, he looked pretty normal, pretty healthy, and then
got that Cheeto face going on. What else? Now what does he look like now?
What he looks like now? It's. Oh wait, that was me. Hold on a minute. It's sad that the man looks. I don't know if you looked at my title page on it. He's sitting in a chair, shack. I mean, they have this guy shackled like Hannibal Lecter. And they have like 8 to 10 deputies walking him through to the courtroom when he goes. Excuse me, folks. It's horrific. 1 second, guys. Let me pull this up. Let me get it up here.
And let's see, when they get their sights set on someone, and this to me is the biggest form of corruption.
Oh, yeah.
When they set their sights on someone, and I've been a victim of this. They go out of their way to create shit to get you hammed, to get you nailed. Yeah. Now, sometimes they do it out of vindictiveness, but sometimes they do it because they really believe what they're doing is right.
Mm-hmm.
And neither one makes what they're doing any good anyway, right?
Yeah.
So in other words, there's no excuse to not follow cross your T's and dot your I's when you're doing law enforcement of the citizenry and you're bringing them to courtrooms, and the judges should be a lot more determined to go against the prosecution, because our system is adversarial, and the judge is there to maintain that adversarial position that the state and government can only go up to this line.
Well,
and if they cross it, then the shit needs to be thrown away.
Agree. I guess maybe blackmail was a strong word, but she went into close quarters with his attorneys and basically said, you can continue with this, but this is going to happen. This is going to happen. This is going to happen. And it's going to make them look bad. So in turn, you have the option to recuse yourself or this or that. And in my opinion, it was kind of a form of blackmail in a sense, but she basically coerced, I guess we'll use that word better. She coerced his attorneys to recuse themselves, even though they didn't want to. They offered to take this case pro bono. They were public defenders and said, we will take this for nothing, which said to me, they know something or feel something strong about him. And you see what he looks like now, okay, as compared to that other picture. This is what he looked like right before he was arrested. This is what he looks like now. Two different people, in my opinion. And he's being treated. Now, here's the thing, folks. Don't get me wrong. If this man did this, then he did it, and he deserves what he gets. But we don't know that yet. Again, just like we had talked about with the Koberger case. We live in America. We have the Constitution. You are innocent until proven guilty, okay? That's not how this has gone. This man has been guilty from the moment he was arrested until they can prove him innocent. And he ain't going to make it, folks. And I hope as if he's not, if they don't want him to. Go ahead.
I want to say something. There's something people to think about, or maybe you could put a 1 you agree or 2 you disagree in the chat room. But I think that people mistakenly have accepted the term loophole when they don't, and the they're taking the Constitution in vain when they do that. In other words, it isn't a loophole. The tax code, for example, allows me to deduct a yacht from my taxes, provided it has a bathroom, a kitchen, and a bedroom. It's considered a second home.
Yeah.
Okay, that's the law. When you talk about a loophole because someone didn't read them his rights, your problem should be with the guy that didn't do his job.
Yes.
Okay, it's not a loophole. It's an inappropriate act on the prosecuting team and or the arresting officers. That's what it is. It's not a loophole like some random, people like I discussion with a friend about, well, you could deduct your truck. Well, you don't pay $100,000 a year to have a job. You go to work for a guy that might have spent millions to build his business so that there's jobs being offered. Of course you get to deduct things.
Right.
Right? That's not a tax loophole. That's only fair. And when it comes to prosecuting an individual and arresting a person for a crime, there are constitutional limits that you must adhere to. And if you don't, we need to stop calling them loopholes because it isn't. It's a malfeasance by the prosecution or the arresting people.
Yes, sir. That makes
Right?
sense. Yes, sir. Like Jesse said, she basically said, either get off this case or I will embarrass you in front of the cameras. And in turn, these attorneys are going to lose their credibility because of that. So they recuse themselves. The other one, Rossi, he really didn't until after the fact. And then they had attorneys themselves to try to keep them on this. It didn't work. And then she just, something is up with that. I don't understand it. They were supposed to in writing, do that in writing, but it didn't happen in that sense. So I don't know. This is just crazy in my opinion. And honestly, even if this man were to be exonerated per se, or the charges were dropped, his life is done at this point.
I'd also like to say that judge that did this shows a display of absolute arrogance and the idea that she is the law and you must obey.
You are 1,000%
what she should have done. What she should have done, if that's what if she could make a decision like that, she should have brought the lawyers into a hearing, and she should have then had a hearing and then made a determination as to the fitness of these attorneys for Mr. Allen. Right?
This judge, yes, sir.
She should have questioned it legally, not in her office like she was John Gotti, okay? That was going to put, or it was the Godfather, and you're going to wake up with a dead horse in your bed.
That is exactly how it went, too, Sarge. That's exactly
absolutely how it went. And who does she think she is? And that's the problem in our law enforcement. That is an absolute perfect example of corruption in that the people that are enacting these services for us think they're above us and we must obey.
And you know that when they brought up the fact that they wanted her to be removed from the case, she threw it out. She wouldn't even look at it.
Nope. And that's another example of corruption within the system that these people have in their head that there's something they're not.
That's right.
That's why even like that word loophole kind of offends me. A loophole is just telling you that there are people that we pay and all the billions we spend on law enforcement couldn't do a simple task of following the rules. That's what a loophole is. It's more of an insult to us as a people than it is the fact somebody got off on a crime.
Yeah.
Do your job.
Right. And you know what's funny? What Noni just said is that Indiana might want to check Judge Gall's body for an odinistic tattoo. That comes off in a form of a joke in some senses. I don't doubt that at this point. It almost seems in that sense as if, because there was another judge, he basically ordered for Richard to go to the prison, and then he recused himself immediately from this, okay? Because of the things that were going on out of protection for them, basically is what happened. This new judge comes into effect, and it's all control. It's this. Everything she did in this whole situation happened with the defense. And I'm not a conspiracy theorist, you guys. Hold on a minute.
Where'd he go?
I'm here. Sorry, I was trying to get my dog to hush.
I know you were.
So, yeah, Judge Diener was the original judge, and I think he knew something was up with this. So anyway, when all this goes down, I was watching it, here and there. I wasn't following it like hardcore because we were all on Idaho. When those things happened, I was just like, wait a minute now. What the hell just happened, And I'm still blown away that these things have been allowed to be what they are. This judge has one of the biggest egos I've ever seen on any judge ever. A lot of them do, but she puts herself up here somewhere like, you can't mess with me. And she was like, I don't know if you knew this either, Sarge, but she was sick and having like medical problems and stuff like that, and wasn't even coming to the office to do her job. She was putting it off on other judges and having them handle things here and there, so on and so forth. So this whole thing is a joke, an absolute joke.
Yeah, and that's that this sums up the issue that goes across the entire nation when it comes to the justice system, regardless of the level, town, county, state, city, federal, right?
Well, this area alone,
these
you're right. This area alone has so many issues. The other case that I carried or covered, the Flora 4 case, the house that burnt down and those children that lost their lives. This is literally a stone's throw from this area where this happened with him. In fact, the fire department that responded to that home, instead of the local department, was Delphi first before Flora showed up, which Flora Fire Department was literally a block and a half away, which blows my mind, but it's whatever. I'm just saying, like, there's so much of this stuff that happens in this area. It's not just this area though, folks. It's everywhere, as we've seen. So
you want to, when I was young, a fire department volunteer was diagonally across the street from a fire.
Mm-hmm.
When they got the call, for whatever reason, they knew it was on this particular road. We'll call the road Joe Road.
Yeah.
Number 4 Joe Road. They were on Joe Road. You follow me?
Yes, sir.
And they went all the way to the end of Joe Road in the opposite direction, looking for a house on fire. Meanwhile, the fire claimed the life of one of the occupants of that home.
I've heard of that happening. Yeah.
Was it an honest? I don't know how you couldn't know that number 4 Joe Road that was diagonal across from you wouldn't coincide with your number 11.
Yeah, exactly. And the way that case went down, it was really, really rough for me to watch because I'm a firefighter, and to see the things that happened, it was really, really sad because a police officer responds to the fire, jumps out. There's people in the house. He knows this. And like, there's people throwing rocks through windows, giving it more oxygen, letting it burn faster, things like that. He jumps back in the cruiser and he heads over to the fire station where they're all just kind of sitting there. And he's like, there's people in the house. Let's go now. And he comes out, gets back in the car and takes off. They still didn't respond for quite a while. Delphi shows up meanwhile, which is another town away. How do you justify that? I mean, I was pissed. You can't. There's no justification to that. And the homeowner was somebody on the board. I mean, there's a whole thing that goes along, but they were actually talking about the possibility of it being linked to this Delphi crap in some senses. I don't know about that, and so don't take that as fact. I'm just saying I've looked at it being, a possibility. V says, what if your conspiracies end up being right now? We are a conspiracy. Are we a conspiracist, or do we just have discernment? That's a good point. Very good.
There's so many so many things argued to be a conspiracy theory that have been debunked that it's not even funny. So the fact that they use that against us is a way to try to shut us up. It's like when they used to make fun of people that claimed they saw an unidentified flying object, and pilots wouldn't report them, soldiers wouldn't report them because they would belittle, shame, and destroy you.
Sure.
And we live in an era now that word conspiracy theorist is another way to say shut up. You're a lunatic.
Mm-hmm.
Right. And in fact, we're just questioning the information they gave us. We're not, when we talk about this case or Goldberger's case, Dager, we're not inventing our own stuff. We're talking about the information they've released that the public is aware of, that you should all read and try to get an understanding on. And it's oftentimes it's contradictory, confusing. Right.
Absolutely.
We're not conspiracists. I didn't write a PCA that claimed the guy turned off his phone when nobody witnessed him do that.
Right.
I couldn't imagine writing that against somebody.
Absolutely. I agree. I agree.
My theories are not the theories that a court of law should use, and even if you're a policeman, your theory is your theory.
Mm-hmm.
Back it up with fact or shut up.
Seabreeze says, where'd it go? It was from the start when the CIA put the phrase out there with JFK. It was a good point.
Right. Yeah.
Excuse me. Sorry
I'm
about
not
that.
a conspiracy theorist. I like to know all sides of an issue, and then I'm going to say this: no matter what it is, there's usually a middle ground on almost 99.9% of every issue that we disagree with in this country.
Mm-hmm.
There is a middle ground on it. The problem is when people disagree and they believe their disagreement is right, they will not have a discussion with you. They'll want to argue or call names or sling crap across the table. So it makes it difficult to have that kind of a conversation with people.
Yeah, no, I can agree. I can agree. Very good point. Carolyn, I don't know about that at all. I don't. Okay. And I don't want to go into something like that as a, for lack of better terms, conspiracy. It was just very strange how it all kind of played out in both of the cases. Okay. And then how close this area was, and the whole Odinistic scenario happened and all that stuff. And it really made people look at it in a different light, you know? So that's why, but that's a good question though, Carolyn. It really is. But I appreciate your input, Sarge. I definitely do. What was the cause of death? On the two girls, Abby and Libby. Is that who you're talking about, Riddler?
Well, it wouldn't hurt to say if you do know. What was their cause of death?
Is that who it was? They were found. Well, I don't want to get like.
Was it strangulation? Was it gunshot wounds? What?
There was. It was. Well, I'll just say it. It was stabbings, basically, sharp object cutting, you know, type stuff. Same type. Not. It wasn't like what happened in Idaho, but it was.
So what does a found bullet have to do with people that were assaulted in that manner?
Because the bullet was found in the area. Okay. Just an unspent bullet, and they said that it matched up to the gun that he
owns. I understand that, but my point is, there wasn't a gun used in the YouTube term of taking a life in this crime.
No,
it was done by a sharp object, not a firearm.
The theory behind it is that he may have racked the gun, okay, and threatened them possibly to get them to cooperate with him, and then the bullet came out on the ground, whatever. But the gun that it was.
No, but again, you're not really following my point. The gun is useless and meaningless in this accusation simply because it wasn't used in any way, shape, or form to do the
I agree. Right? Yeah, I agree.
So then if that is in a PCA arrest or in charges, it's another theory that doesn't belong anywhere near this case. No DNA on the bullet, no transfer DNA on the bullet, but a bullet that has the same caliber rating as a rifle that man owns. It's ridiculous to even mention that in this case. They were stabbed, right?
I do agree. Yes, I do agree.
Unreal, man.
That's what the theory behind it was. I feel it has nothing to do with this, and that's what they're using. There's no fingerprints. There's no any of that. And like I said, the girls were unalived through stabbing, and then they were staged. Okay, in a specific area. They had sticks laying on them and different scenario. I thought you were here for that one time.
Was it a revolver bullet or a rifle bullet? Did they say is it 40? Someone said 40.
It came out of a SIG. It was a
yeah. So
yeah, it wasn't that type of a gun. Okay. So I agree. It's absolutely, and Eddie just said the same thing. Absolutely ridiculous to even bring the bullet into question.
Yeah, I mean it's like bringing up what you ate for breakfast.
Right. I agree. I do agree with you.
We're conspiracists because we notice the obvious. Jeez. You're getting me ahead.
Yeah, and then there's a recording I forgot to mention too. There's a recording that says, "Okay, guys, down the hill." They show the whole. I'm sure you've seen this. Okay, 1 second.
No. Like I said, I'm not that well schooled in the case. In all fairness,
right?
So,
let me show you,
folks, and I apologize ahead of time.
No, you're fine. You're fine. This is the. Let me find it here. This is him, according to the police. They believe that this is him. Okay. And this is a looped video that, in my opinion, has been doctored. Then there's a recording of two different people, in my opinion, not just him, stating, okay, guys, then down the hill, basically SRB, yes. And
did they find that guy's clothing in his possession that matched that video?
I do believe he has clothing that resembles this, but there's also another guy that we came to find that very much matches this description, owns hats like this and everything else, and could be the same person, folks. So
see, I just asked the same question I did.
yeah. And then why would the police believe this was him to do? Right, exactly. I don't believe they did, honestly. I mean, and then that's David Clayton has another point. How did he get them across the river to the creek? Great questions.
Apparently at gunpoint, from what they're trying to allege. It sounds to me like they're alleging that he held them at gunpoint to get them to do what he wanted to do.
Yeah.
And they went where he told them to went. That's the argument they're making here, right?
That's pretty much it right there in a nutshell, yes.
See how we asked the same questions, but I pulled the trigger first. Fun on words.
And then the lab determined that the unspent round had been cycled through Richard Allen's 6-hour P226. So it's like, okay, based on the markings that were on the bullet.
Absolute nonsense. If anybody bought ammunition, you'll know that there's been a shortage of ammunition, and most of the ammunition you're going to buy is going to be consistent with everybody else that buys ammunition. That's how it's been for the last few years, right? There was a shortage of that. And so, you know, if you get a Winchester 40 caliber bullet at Walmart, believe me, that's probably the only brand that Walmart's offering, because there was a shortage. So 10 other people have that same caliber bullet from the same manufacturer. Because he had the same manufacturer in his clip doesn't mean that the bullet you found on the ground that matches what's in his clip makes a connection. I mean, that's like having two different orange t-shirts, right? I could have one, Dago, you got one, you're wearing it. And so what does that say?
I agree. And then now we have another issue, is there were sketches drawn for this, okay? And the sketches, granted, one of them does resemble and could resemble, but the other one is of somebody much younger, somebody that's got curly hair, no hat, looks like he's probably maybe 20 years old. They never even went to that sketch, okay?
So who produced the sketches? Based on what were the sketches produced?
Witness accounts of who they saw that day in that area.
And they saw this guy in that area. That had to be after the crime had been committed, correct?
Yeah, around the same time as what they're saying it happened in. So
okay,
I'm trying to find the one so I can show you, because the younger guy, the sketch of the younger guy, really should have been looked at, in my opinion, a lot more closely. Okay, and it wasn't at all. I'm trying to find the version of these to show you real quick.
All right.
Okay, here we go. So these were the sketches. Of course, this is supposed to be Richard Allen. This is the other one that nobody, it wasn't looked at. They didn't even look at it twice. Now, mind you, this case happened 6 years ago, going on 7, okay? And it went cold for 5 years. Then all of a sudden, out of nowhere, Richard Allen's arrested. Kaboom, we have a suspect, okay? Which was wonderful. But again, just like the things that we looked at with this, once he was arrested, and there was multiple other suspects, an older gentleman, you know, that it happened on his property, basically, that there were things on his property, I should say, that happened, so on and so forth, but he's passed away now. There's just a lot of things that don't match up to this, okay, at all. Let's see, this guy here.
So this person saying it's an altered sketch, so the sketches they're claimed to be altered by the authorities?
It's been stated that way, yeah, it has been. Yeah, and he was arrested basically on the bullet, yes, CL. That was pretty much it. And the fact that he claimed he was there that day, okay? He had no issue with that. He was there that day, so on and so forth. That was it. So it just didn't match up. Other people were seen around the time that this happened. Three boys were seen by a lady that lives down the road. I mean, it's just a
So
lot.
he lived in this area? And let me ask you, was he aware of those crimes for the last 6 years?
Oh yeah, yeah. Everybody.
Okay,
knew in
so
that
my
area.
question is, did he ever come forward and identify himself as being in the area when the investigation originally began?
Yeah, he did. He told them he was there that day in that area.
6 years ago.
Yes. Yes.
Okay. So he wasn't hiding anything.
Basically, in that opinion, no. But the thing is I don't think this looks like him. A lot of people do.
No,
It's just me. This here though should have been looked at, and it never was. They didn't pay any attention to this, in my opinion.
Did they find a hat that matches this drawing? Did they find a hoodie that matches the drawing? This shows a COVID mask.
No. This here is they don't even put this into the barrel with the rest of this stuff. But
yeah.
And then the other gentleman that we looked at, okay, I'm gonna show you this too. That came out. It came out not too long after some things happened.
Do you have a recording of his admission?
No, nobody does. But I believe that it was coerced. I can visualize him standing at the phone telling his wife this. And I know this is conspiracy like, folks, but based on everything else I've heard about what goes on, is I can envision him standing there doing this with COs on either side of him, basically forcing him to do what he's doing. That's my thought. I'm just saying. And it doesn't have to be, okay? Doesn't have to be true. But now,
well, you know, a forced confession, just so you know, doesn't require that. What that would require is you place somebody or you threaten somebody with circumstances that are so intolerable that you're telling them that if they admit to what they did, that this will all change for them. It'll be over. That's how you coerce a confession.
Anybody, anytime he talks to anybody, his attorneys, this, that, and everything else, the first thing he asks people, how is my wife and kids?
Right.
Okay, so this is the other guy that came into the picture slightly after the fact.
That resembles that image.
This is Brad Holder.
Yeah, he resembles that drawing, I think, more so than or at least equally as much as the other guy.
Thank you.
Right?
Okay.
No DNA at the scene. They didn't find anything that they could go test.
No.
So another sharp object and nothing left behind at all.
They found one of the girls. When they found them, they found the girl's phone underneath her. And again, they were laying in it. They were staged in such a way with sticks on top of them. And I can show you that too. But it's basically, I mean, this picture here.
Were they posed? Were they basically posed?
They were posed in a specific positions that matched Odinistic. The word's slipping my mind, but
Can I just say that with the Idaho 4, based on that one policeman saying that the two bases were perfectly untouched, they were like angels. I wonder if those weren't posed as well.
I mean, it's possible. It is very possible. Very possible.
Or if their heads were covered with a bag or something to keep them from getting,
I can agree. Let me see here for a second. I'm trying to show you something.
Yeah, this is what led up to the Odinists or whatever, right?
Yeah, basically.
Yeah.
Okay. But it was looked at 6 years ago and then kind of like just tossed to the side. Hold on, man. Let me go back up here and see.
There's a video too of RA wearing a dark blue coat, similar looking to the one seen more in the video of the bridge guy.
Yes, there is.
Which really, again, it's another. He admits to being there, and he admitted 6 years ago, right?
Mm-hmm. Yes. Absolutely. Hold on a minute here. I'm trying to find it. Oh man, I don't see it. Oh, there it is. Indiana. Is that what you're talking about? What'd you say?
I'd like to ask you a quick question. On the bullet, when they said it had been cycled through his gun, when they looked at the gun, was the gun clipped short one bullet?
I don't think so.
Do you follow me? So let's say
I do. Yeah, I do. I don't think so. I don't think it was like that. This
So-
again happened years afterwards. You know what I mean? Thank you, Brian, so very much. I appreciate that.
Yeah, that's a problem. Years later, he may probably use it in the intervening time.
Honored. Yeah, that's what I'm saying. Did I miss the comment, Mountain Man? All I saw was Indiana. Is that the last comment?
It's a magazine, Sarge. Yeah. It clips into the bottom of the gun. I know what it is. But so, yeah, see, that evidence is just so weak and it's so out of place to use that as a way to say he was there. Yeah. And most people, I don't know, do you carry it around in your chamber when you move around with your firearm, Dago? If you've got a firearm, don't even mention it. But I'm saying I don't think most people move around with one chambered ready to go.
No, it's I keep
unless it's a revolver, that's always the case, unless you have an empty hole, right?
It's unracked and just sitting there ready to be
right. And you then rack a bullet into the chamber. There's no reason for the bullet to fly out of the gun.
Absolutely.
Right.
And like I said,
you know,
the theory was that when he was trying to get control of the situation, he racked it once and, maybe lost a bullet in that sense. But I don't believe that. And then,
no,
of course,
I don't find it at all, man. It's like a knife being carried in a sheath loosely.
Right. And the picture of that guy that I just showed you that said looked more along the lines of that sketch. His son was dating one of the girls.
So he knew the girls. He was in their circle.
Yes.
How about Mr. Allen? Was he in their circle in any way?
No. And he's the only one that didn't have out of all the suspects that throughout the years, the only one that didn't have the criminal background like everybody else did. So he worked at a CVS. That's what he did. I'm not saying you couldn't be a killer because
right.
I'm just saying this guy had
the
most
circumstances as presented make it look unlikely more than it makes it look likely.
Yeah. Yes, sir. That wouldn't matter though, because he could have shot many rounds. That's true too. That's true. Agreed, dude.
Yeah, I agree.
Yes.
Yeah, I kind of thought of that as I was spitting out the idea in my head. Then it came
very
to me.
true. Very true.
6 years ago. That's why you said it was 6 years ago.
Yeah.
Yeah.
Oh, okay. I guess Teresa said that Kathy Allen has a picture with Tara, who is Becky's daughter. So, okay, I guess there was some form of interaction there, but not as much as the fact that this other guy.
I dated a girl named Tara.
I did too. That's funny.
Yeah, it is funny. Mine was a crazy redhead.
Mine was blonde.
She was awesome.
Well, not real blonde, but still. She was still blonde.
She was awesome.
Yeah, I wholeheartedly feel like Richard Allen is being completely screwed on this. They say that he had a SIG 226 that is a 9mm platform, not 40. The Indiana State Police adopted the SIG 227 in 2013. That is chambered in a 40 cal.
Yep.
Thank you. Good point.
Well, then if he doesn't even own the gun that would handle that caliber bullet, how can they argue that it was chambered through?
Based on what I understood, he did own a gun that matched up. Thank you, Lucille, very much.
Right. Okay.
Appreciate that so very much. Let me go back here and see if I can see who's getting it.
But that's a very common gun.
That's what I said.
I think that's the most common handgun out there.
Teresa said he owns it. So that's what I had thought, that he owned one just like that.
Yeah, that's weak. That's so weak that like I said, it's like saying the guy turned his phone off when you weren't there to witness it.
In my opinion,
conclusions based on bullshit.
Yeah, in my opinion, it's weaker than the whole transfer DNA that they have on Koberger at this point. And I'm not bringing that case up to talk about. I'm saying,
listen,
relativity.
Look at your chat room. I nicknamed Cletus and I nicknamed Jennifer Cum Dumpster, and it's stuck. Both of them. Look at that.
Pop and grabber. Yeah, that's the other thing. I'm gonna find these pictures for you real quick. But she said, I about threw my computer out the window when I watched the video of her saying this, that it's just coincidental that those tree limbs just fell off the tree that way.
Yeah.
What? This woman is so stupid. I swear to God. I don't understand how she ever worked for the FBI doing anything other than cleaning bathrooms. I'm sorry. And that's, if anybody likes her, I'm apologetic. I don't mean to offend anyone, but I can't stand her.
I can't stand her either. You know why? Because there's a woman that's the epitome of corruption. The government is never wrong. And its agents of the government are never wrong, ever, with that woman. unless somebody gets caught blatantly doing something wrong, like in the Gigolo case, right? Or whatever you want, right? And unless it's like a bomb went off in front of her, there's no such thing as explosives. That was an errant bomb. You'll never see that again. So she is so one-sided in her narrative, which is
completely nothing
I'm
but
the law. Yeah, what I say is what you go by, and I know everything, and I am the cop. Ugh. Sounds like someone.
She won't even listen to anything anybody has to say on the other side of the fence at all. Okay.
Nope.
And to not listen to or even remotely look at both sides, how can you do that? Because I look at both sides. I look at the fact that Brian Koberger could have done what he done in that case. I look at the fact that Richard Allen very possibly could do what they're accusing him of in this case. The thing is I also look at the other facts that point away from the fact that these gentlemen are the ones that are responsible for this, and the fact that there's not nowhere near enough evidence, in my opinion, to put them in these places at this time doing these crimes. You know,
I think the common ground we all share is justice means proof.
Yeah.
Right?
Yes.
Not partial proof, not stories of proof, but actual proof that that we expect as Americans that our government must provide to take our freedom from us. It's all, especially if you're above the age of 35. I don't think anybody would disagree that that's what they expect from the justice system. Nowadays, a lot of the justice system is based on personal perspective of the world. Your worldview is being imposed upon defendants or your opponents, right? Rather than the law being followed. And that's why we always question, what the heck's going on with this? Where is the evidence?
Agreed. I agree. Real quick, off subject, but heard on Robert Hawley yesterday that he had one of D's goons show up at his house threatening him, said his boss, D, said to stop talking about him or else made a police report. Who is D? Are you talking about like Dylan? Oh, or I don't watch Robert Hawley, so I don't know. Are you talking about Demetrius? Really? Is that true? If that's who you're talking about.
Is that guy with the new stream? Is Robert Hawley a lawyer?
No, I think he's an older gentleman. Let me see real quick.
Because there is somebody out here, a newer guy, and I keep thinking his name is Hawley or something.
He is new.
And that guy puts out a lot of fake information. That guy goes off on some crazy stuff.
I've
listened to him. I mean,
I agree. Is that who you're talking about, Fallon? This is the guy I'm talking about. This is who I believe they're talking about. Just to show you who he is.
I think I know who it is.
It's this guy here.
But I'd rather know for sure. I mean, and I'm not. Yeah, that guy. Yeah, turn that off. Click that off.
Yeah. I don't watch it. I watched one video by him, and I was just like, no, but you're saying a bunch of wrong stuff. So I
posted some corrective information in there. He was like, thanks for the reply. Didn't engage in it. Didn't have any. Not a thank you or I'll consider that. Just thank you for the reply. Whatever.
Yeah,
and it's the same thing I posted in other people's threads too, where the same mistake was made, and I wasn't rude or nasty or anything about it. I just pointed out that.
Sure.
I forget. I was in the stream today, and they were claiming that one kid went to Africa, but that was established that he didn't go to Africa.
Yeah.
There's still people out there saying that he went to Africa, one of the jacks. Right. So.
Yep, that's right.
Yeah, there's a lot of mistaken information or rumor that's being pushed around that it causes chaos.
I do agree, sir. Oh God, please. Riddler said that Richard Allen once processed photos for the victim's family for free. Grandmother says through the CBS. Yeah, Yeah. Although we have
Yeah, so he's got a connection, but I still think it's always incumbent upon the government to show enough evidence for a conviction to be reasonable. In other words, I give them allotments for being honestly wrong. It happens to all of us, right?
Right. Welcome, Jimmy.
I'm okay with that so long as we got systems to double check and correct our wrong.
Welcome, Michael.
These people are never wrong.
Yeah, and that's another thing. Gordon's right that she blocks and threatened the lawyers that were trying to correct her for the things she was saying, and this is what she does. I was blocked on Twitter from her like within seconds of adding her on Twitter because I didn't agree with what she was saying, and I asked a question. I was out just like that.
Can I say I went on Twitter and I said, is it you're the most something disrespectful FBI agent I've ever saw, and in my mind you'll always be Jennifer Cum Dumpster. And people started hitting the like button, right? And I'm watching this and I'm refreshing my screen to see what happens, and she just comes out there and says something like, "You don't need to be rude," and blocked me. So yeah, I can't see what
she's been rude to other people. She's rude to people all the time, and she okay, I see what you're saying, Annie and Fallon. That's insane. I mean, really? Because they haven't said a word in months. Now they're going to start talking about stuff, and I don't know if I believe that from this guy, but whatever. I hope that if it's true, I hope he did what he had to do to cover it. And if it's not true, dude, you're not going to get attention doing that. You're not going to do nothing.
Someone came to his house, another outrageous claim, right?
Yeah, he said that one of Demetrius's goons came to his house and threatened him to stop talking about Demetrius. That's dumb. I don't believe that, because here's the thing. If this person has any sense, they're not going to do that like that, because then it's going to be reported to the police that happened.
It goes even worse than that. Let's take Demetrius right out of it. Okay,
that's what I'm saying.
Again, here we go again. I need the evidence before you make the accusation, dickhead. Okay,
Good point.
I need the evidence before you argue this particular topic. If there's no verifiable fact to support your point of view or argument, I don't want to hear it. So for this guy to come out and say that, show me you mean to tell me you didn't have your phone? You didn't take pictures of a car leaving your drive? Nothing?
Nothing. Please. That's the point.
Please.
Exactly.
Now, if he produces them, then perfect. Right? But you have no evidence that this situation ever happened. And for you to come out and make statements like that, you really should be banished, is what you should be.
He claimed that he filed a police report. Well, that doesn't mean anything. You could file a police report on anything you want. If there's no proof of it, and it's just an empty report. So
I could call the police right now and say, someone robbed all the stuff from the bedroom upstairs that I haven't used since I've lived here. And they'd go up to an empty room. I mean, how could you argue something wasn't taken?
Right. Oh, okay.
Anyway, I don't know the man, but I do question the claims that he makes as being outlandish and unsupportable by the available fact.
I agree.
As far as him as a person or anything about nothing, I have no comment on that. I don't know the man.
Well, as another creator, I'm going to say, I hope it was true on his behalf, because you're going to get yourself in a lot of trouble doing stuff like that.
I don't hope it's true. I hope it's an unprovable allegation that he's made. Right? I mean, people need to wise up and be very careful about third-party stories like that, or claims of direct involvement in any of these cases.
That's what I'm saying.
When they're doing it for attention.
That's exactly what I mean by that. So,
yeah, I agree with it. You're the man, Dago.
Yes, sir.
All I said is you're the man, Dago.
Dago. I wouldn't say that, but it is what it is.
All right, so where else were we with this poor guy, Mr. Allen?
That's it, really. We're just waiting to get the we're waiting to get the results back from the Supreme Court hearing, and hoping that they file for him to give him back the defense team that he requests. If that happens, then the trial is going to start in 70 days.
No, if that happens, this judge is going to have to remove herself, or she's going to be petitioned for removal.
Well, that was part of it.
There's a lot more to come. If the court rules in his favor, it's just going to be more legal maneuvering here to get rid of her.
That was part of it as well, I do believe, was to have her removed as well. So I don't know how that went because I didn't catch any of that. I don't know what the filing was on that, and I'll have to wait and see. But I will report it for sure when I get the actual info on that. But she should have been. She should have been before this all happened, in my opinion. But it is what it is. She's not going to do that because it's going to make her look bad, and it's all about ego with her, in my opinion. So, you know, I don't know.
I don't think she's going to have a choice. I think she's going to have to step down because now she has a conflict of interest. She actually has the motion she used in court to argue against that lawyer being taken down. That lawyer can use that motion against her.
I agree.
If things are done properly, this should be interesting. And then,
I agree.
sadly, this guy's in jail. Regardless of his status of did or didn't do it, he's still rotting in jail.
Absolutely. Absolutely. I do agree with you, sir.
And he was out there for 6 years. Under what basis are they holding him in jail? I mean, he could have ran away 6 years.
That's what I'm saying. I don't believe it was just very weird. I mean, I'll put it this way. I didn't really follow the case too closely, but I was excited to see they had a suspect in custody, just like I was with the Koberger thing. And I was like, okay, great. And then you start looking at how things are all unfolding again, and it's like, here we go again. But this is real. Like, this is all the conspiracy stuff that's been thrown out there as conspiracy. For I hate using that word again, but dude, guys, it's in our face. It's not conspiracy. It's real. All this shit's been happening. Okay.
You know, when I got a sidetrack, you were going to show how those branches landed.
Oh, yeah. Sorry. I'll pull that up.
No, that's my fault. That's my fault.
All right. I wanted that Robert Hawley thing got my attention too, but thank you, Brandy, for that. And hold on a minute. Let me pull this up. It was quite interesting, to say the least, when I seen this, because I was like, well, damn. And they also found on the tree behind them what looked like it was kind of in the form of an F, it's an Odinistic rune looking type scenario on the tree behind them in blood. That was another part of it, but let me find this here real quick to show it to you.
Somebody said that, unless I'm misunderstanding this, but that particular guy that said D came to his house, that's that Doodlebug's husband?
No. Oh, no. Oh, good Lord. She's going to come to your house now.
Oh, hey, shit. I'm like, there's no way she could have married that man under any
No, they were talking about her.
The way she views the world would not allow it because he's so far out there.
They were talking about her and Michael 007 joking back and forth is what they were talking about.
Oh, okay. All right. See, I don't know the inside joke. That's why I was like, what do you mean she's married to that guy?
That's what they're talking about, not him.
That's funny.
Oh my
Sorry,
God.
Doodlebug.
That's horrible. Okay, let's see here.
Ghost stories. True crime. How long will it take until a hearing ruling from the Indiana Supreme Court? Could be as quick as the end of the day. It could be weeks.
Yeah. I'm hoping that it's quick. I'm gonna give it 48 hours is what my thought is on it. But
Friday at dinner time.
Yeah, we'll see.
No one's paying attention.
We will see. Where is that? I have that downloaded in here, and I'm trying to. Wait a minute. Here it is. I think this is it.
And if based on the defense's presentation, if the court were to rule against Mr. Hawley, they're setting a new precedent in the understanding of a law.
You mean against
basically giving judges power to remove defense attorneys in ways that has never been done before.
Right.
I don't think the Supreme Court. Who was that? Was that the Indiana Supreme Court there?
Yes.
Right. Yeah, I don't think they're going to set a new precedent.
I agree.
That's very rare for a Supreme Court to do that, unless it's obvious, where they go back and correct a prior. So maybe the precedent that was used to support that particular whatever the defense gave or the prosecution gave was whatever, but it's very unusual, not very common.
Yes, let me see something here. I had these downloaded, and now 1 second.
Yeah, I'm not. No. I'm patient. No problem. How's the weather out there, Dago?
Cold, and we're getting snow.
Much of it, or just a trace like I'm getting?
We're supposed to get 4 to 6 tonight. We'll see.
Yeah, we haven't gotten anything like that, and it's.
I'm surprised because you guys usually get it quicker than we do.
Usually, yeah, historically true, but over the last many years, I don't know that that's. I think we're more even with you, or maybe even less many years in a row.
Mm-hmm.
Yeah. I really haven't given Mother Nature my consent to do anything horrible here with snow in a long time, so that may be why.
Gotcha. Okay, give it to me. Where's it at here? Come on, show me pictures. Yeah, it was colder than hell here yesterday. And it's actually quite a bit warmer today than it has been. But we're supposed to get this snow tonight now, I'm guessing. We get that lake effect crap. And if we do, then here we go. My son had school. They shut down the school yesterday. It was so cold. Like 20 below zero with the real cool.
They never did that when we were young.
No, not for that. They shut it down for snow, but never for the.
Yeah, but usually a foot or more, not for.
Oh, well, we used to get
inches of snow like they do now.
Yeah, we used to get snow like that. That's the thing. Oh, wow.
Those kids only knew we walked to school both ways going uphill. If they only knew the
wrong direction. Yes, the wrong
direction. Right. Kids nowadays don't get the struggle. But you know what I find it's kind of a dynamic. You work so your kids have it easier, right?
100%.
And these last few generations have gotten that, but it's been like it's like a point of contention. But that's kind of what we want for our kids. I don't want them working, in a coal mine somewhere.
I agree. I do agree. Yes, sir. Yes, sir. Hold on a second. I got to call this out real quick because this is pretty awesome. War Eagle gifted 10 memberships. Thank you so very much for that, War Eagle. Looks like Peaches 81 was gifted. Sherry and K Dips 18. Brandy B, Newman 25, Claire S, Kate was gifted. The Snooper, Mrs. Krampus, Peppermint Cheek, Cindy Kerf. And I'm telling you right now, I deeply appreciate that so very much. Welcome to all the new meatballs. And again, War Eagle, God bless and thank you so very much for that. That was amazing. Thank you. Thank you.
There's an apparent crime of seduction happening in your chat room.
What?
Yeah, Doodlebug Fart is one of the suspects. Just be aware.
Uh-oh. I wouldn't mess with Doodle. I wouldn't mess with Doodle at all. She said, ha, 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 ha. I am guilty of.
She confessed. Lock her up.
Yeah.
Right?
She's guilty of love. Yes, she is. All right. Damn it. I'm going to find this. I had this video downloaded, but my downloads were like, they overflow sometimes. And, oh, wait a minute. Okay. Here we go.
I'm waiting on Huda of London to send me some videos from yesterday. I talked with her.
Oh, really?
Yeah. Yeah, she's a trip, man.
Yeah, she is. What the hell? Why does this keep doing this? There we go. Bring it to me. Okay, here we go. Now, this isn't showing the actual crime scene with the actual victims, but it gives you the diagram that they made of what it is. So, okay, so this is how they found the body, Sarge. Okay,
it's like a peanut. Okay.
Libby was found over here like this. Her arm was lifted up this way, raised up, and the sticks were laid across her like this. Over here, Abby was found this way. Okay, now the weird thing with this is one of the girls was found with no clothing on, and the other was found wearing the other one's clothing. Okay.
All right.
And then this tree was behind them, and on this tree was another, what looks like it could be a Odinistic rune. It looks like an F.
Was it sampled for blood?
It was blood. It was blood.
There's no doubt that it was blood. Was it any of the victims' blood?
I do believe so, yes.
Yeah, it was.
Yes, sir.
Okay.
After, of course, the unaliving happened.
So that to me is enough evidence to conclude that somebody connected to the Odinists were involved here.
Well, of course. That's my thought on it. But
what do those runes mean now? Now, what are those shapes? It looks like a cross placed on a V. The other one looks like a cross with a diagonal in it. But they both look like.
I looked them up back. You see what the problem with this is whoever did this was not. They took the religion of Odinism and or paganism, whatever you want to call this, and they twisted it into their own fashion. This is not realistically what this is supposed to be. Okay, that was the problem. Because we looked into, we did a whole.
I don't understand.
Okay, so somebody looked into this, but they screwed it up. They didn't do it the way they were supposed to. This is not like relative to what it actually is supposed to be. And they're stating that it's very like, it's based, the whole thing is based off of like a white supremacist scenario, so on and so forth was talked about.
And these young girls were white, correct?
Yes, yeah, and one of them was completely drained of all blood. There was no blood at the scene, and I believe that they were unalived somewhere else and placed here. That's my thing.
There was no blood at the scene, and the young woman had no blood in her.
Right, completely drained, which goes back into the Odinistic theory.
I hate to ask this: were there any signs of animal interaction with the deceased?
Not that I know of, no.
Okay, so there's no argument that there was any wildlife involved after they.
Right. And there's a couple of other things that I have that are facts that I'm not going to talk about. I just won't do it on here.
Well, I'm just curious I'm trying to understand how there could be no blood at the scene, and she had no blood in her. That's why I asked that gross question.
That's why I think that they were unalived somewhere else and brought here and staged.
Right. If there's no explanation as to how the blood could have gone missing at that, and there's none at the scene, then that obviously is not
they drained it. It seems to be that she was drained completely. Okay,
at the scene, or do they have
wherever the actual crime scene is? Where they found them is not, I believe, not where the crime scene was. It was somewhere.
All right, but I'm asking you. They claimed the body was drained. Do they have evidence to support that it was drained in that location?
No, that's what I'm saying. There was no blood in her body, and there was no blood there. So therefore. You know what I mean?
Nothing on a leaf or a bucket or anything like that. Nothing at all to indicate her blood was moved into a bag or anything.
Not there, no.
Okay, well, that's bad news for the prosecution.
Yeah, and then Teresa says that the hangman position on RCHARD was how Abby was posed. Right. Yeah. Teresa says there's animal antlers all over the area, but like there's no.
Yeah, but they're what do you call that?
Shedding.
No, antlers. No, they don't. They're not carnivores, and they wouldn't drink blood. They're
no,
like a cow. They're
yeah.
What do you call that? Herbivores.
They're herbivores.
Yeah, herbivore. Okay, so yeah, so the animal any animals around that particular location would be animals that would have no interaction with blood.
Yeah, right. The right side of her face, left leg were straight, right leg was bent. Right. Exactly, Kate Dips. Thank you. And Riddler says, didn't Ellie first have another suspect nearby until the elderly? Yeah, they had a few other suspects, actually, Riddler. They had Keegan Klein. They were looking at that older gentleman. I always forget his name. There was a multiple different people they looked at it at different points, okay? Until they laid their eyes on Mr. Allen, and boom, there he is. And here we are. So I personally feel that Greg says, did you cover Judge discovery ruling with regards to the genealogical tree evidence?
Yes.
Yeah, I did.
It was the partial release, remember?
Yeah, we did talk about that last week. Teresa says no blood at all on Abby. Rumor is that she was drained of blood. Correct. And like I said, it led me to believe wholeheartedly that
where's the information? Wait, where did the information that there was no
in a
blood in her?
It was one of the documents that they had. It was in a PCI, I do believe.
That all blood had been removed?
Yes. Yeah. When they found
So
her,
that's an illegal document then. That isn't somebody making the claim.
Oh, no. That was that was part of the crime scene or in the PCA, basically.
Okay, well, I'm listen, I didn't doubt you. I assumed that. I didn't even question it originally, but watching the chat room, I thought it'd be a good question to ask so you can clarify. That's all. I assume that when you're bringing up her body is drained, I don't believe you would do that on a rumor.
Oh, no. Yeah, we found that.
So the only reason I asked was I trust you 100%, but it's nice to know that there's a document to support it. Sure thing.
I agree. We've had enough of that kind of stuff happen that we don't need any more of it. Let me find. There was something else I was trying to look at to respond to here, but this is what happened. Like I said, the tree behind it had that other rune marking on it in blood above their head, above Libby's head there on the tree. And, they're trying to say that it's some sides of it are trying to say, oh, that's not what this was. Like I said, Coffin Dauber said, that's just a coincidence. The branches fell out of the trees like that. What? I mean, that's just stupidity right there.
Yeah, I don't know how branches can end up in that. And both branches fell in a way to create a cross that actually covers the women. I just, what I'm doing is if you look at, you see the cross, take the V out. It looks like there's a cross leaning across that young girl's body. And the one laying down, it looks like there was a cross placed on her and then somebody put a diagonal through it.
Yeah.
So how does it? If a tree can do that, we need to have a conversation with trees and stop building their stuff out of wood. Okay.
Mm-hmm.
Right.
Absolutely.
They're reaching out to us.
Thank you, Natalie.
Common Doppler is gone. She's just gone.
Yeah. When she said that, I about fell out of my chair. I was just like, "What did you just say?" Like, come on,
They believe these things they say. That's the worst part.
Oh, because she worked for the FBI, so she must know what she's talking about. Get out of here. That's dumb. Completely dumb. And that's what I thought too. Is Josie just said I had once heard the girls were stabbed.
Might I ask a question? Do we have any images of the original location of those branches?
No.
So this is a rendering. So just keep in mind, folks, that these photos show a very accurate depiction that may not be quite so accurate.
Here's what happened with this, Sarge. This is what blew my mind, and this happened years ago. When they found the victims, they moved this stuff all to the side. They tagged everything for what it was, I guess, and they left the sticks at the crime scene. This scene here, they took the victims away as they, when they were done doing what they did. And they came back later for this stuff. What? How unprofessional is that?
But one would suspect they took images before they moved anything off of the body.
They did. They did all that. That's great. But why would you leave the sticks there until 2 weeks later and come back and get them after knowing that they're going to be trampled over by animals and people possibly, and dirt and rain and all that stuff? You're going to leave them there for 2 weeks, come back and get them?
No.
That's ridiculous.
Again, it's the same thing in the Koberger case with all of this nonsense going back and forth. The timing is all crazy.
Yeah.
The actions of the law enforcement agencies don't appear professional in any way, shape, or form.
Yes.
Right?
Exactly.
I mean, I can't believe I argued with somebody that if you're going to use trace DNA, then the crime scene needs to be inspected only by people protected in such a way that trace DNA can't come off them.
I agree.
Right?
Yes.
You don't send them in there with windbreakers and rubber gloves and regular clothing. And then you're going to use DNA. Then you're going to pick up trace DNA, transfer DNA, and use that as evidence. Well, you weren't prepared to investigate a scene with evidence that particular.
Exactly. Yes, sir. And yes, see how that's true.
It's like running into a fire with a hose without turning on the water.
Mm-hmm. And then
what fireman are you?
Yes, and David's correct. Said Libby's phone was found under her, like someone wanted it found. I agree. And it just blows my mind. Like Eddie's saying, you leave them there for 2 weeks so that the evidence becomes degraded. Rain and weather and all that. Absolutely.
Imagine if they could have swabbed for transfer DNA and got lucky. They lost 100%. That opportunity when they left the stuff there for 2 weeks, right?
It's unrelenting how stupid this is. And then they act surprised when people say, "What are you guys doing? Are you kidding me?" Their clothes were found in the creek. That's correct, Tomboy. Like I said, I wholeheartedly feel that there is another crime scene where it actually took place at, and then they were brought here and staged. There was a news helicopter that took pics over the area where the girls were found, and those images do show them found very much like the example given. Gotcha. Okay. Go ahead, Starge. You were going to say something.
Yeah, I was watching. I bounce around on different streams, even people I don't like, just to see what's going on. And
right, absolutely.
You know, there's with this order of unsealing, there's some people out there suggesting that the sealing is protecting an actual witness. And I say the sealing, the witness is protecting is the FBI tip. Okay, that's always been my understanding. And I just wanted to say this is, if there is a witness, then they must have come in to the situation very close to the time Kohberger was arrested. And the reason I say that is, if there's a direct witness to this, I suspect that they would have used that witness to arrest Mr. Kohberger and not let him drive 2,500 miles. You follow me?
Yes, sir.
I had seen this point put forward on a couple channels that they seal it to protect a living human being witness, and I just don't see any evidence of that based on the timeline of events.
I can agree. I can agree, my friend. Definitely.
Teresa said the drawings are from the crime scene photos. Do we know who did the drawings, Teresa, or how they had access to those photos?
So this is a helicopter view. Hold on a minute. From the crime scene. Let me throw this up real quick, just in case if this were to upset anybody. It might, and I don't want it to. So if you will have to step out, I understand. Let me see here.
Viewer beware.
Yes. See. Yeah, the defense is where the Otis based on something stated.
Why can't they just get to the point with videos like this?
You gotta make it so dramatic,
Yeah, like they're CNN or something. Come on.
Right. This is YouTube, baby. Thank you for joining us today. Horrible video. Wholeheartedly.
Have you seen anything yet?
No. I'm guessing it's in this realm here.
I don't see a person there. Is that
I don't either. I'm guessing.
Stop the film right there. Stop it. So they're saying that's the person, and that's the branch lane across them. That's the victim,
That's my guess.
right? But that seems awful big in a very distorted way. Like that person's giant.
It's hard to see. Very hard to see. It's the way they have it.
Very disturbing. Were their heads covered in something?
They were covered in leaves, I'm guessing. I don't want to show too much of this, but
Okay, so you can.
yeah, I don't see anything personally. It's just somebody told me to go to that. I can't see it. I'm sorry. It's really blurry. I'm sure that was done on purpose, but I haven't seen any still images either, Noni.
Yeah, see, and that without still images from the way the policeman found them, this I don't give any credence to that video at all because we're being told what to see.
I agree. I do agree.
And
Like
once that happens, yeah, it's like being told how the magic trick works, and then the guy does it, and you're just
like being told what you hear in the audio from the Idaho case. We know what we're going to be listening for, and we're going to hear it. That's how that works.
Yeah. Once you tell me what to see, my brain is going to try to find it.
A suggestive visual and audio. It happens all the time.
Now I want to be clear. I'm not saying that this video is touched, faked, or there's someone being goofy with it, but I'm saying if there's pictures that you would expect the police to have made once they got to the scene and they corroborate this particular pattern of sticks, then
they have it.
Got something
that you can't see anything, so that's it. There's no point in looking at it.
And what images did that guy? Somebody stole images and released them. Do you know what those images were of?
No, I have no idea what they were.
Noni might have more for you.
That's another one. People's minds play tricks with blurry footage. Yeah, I've never seen those, Noni.
Yeah.
I mean, honestly, I don't really want to see. That's what happened, Sarge, was that whole thing. Somebody that used to work for one of the defense attorneys that was removed went and see it. To me, it was done on purpose. And I'm not going to like say who did it, but I'm just saying there was a gentleman that went to visit Attorney Baldwin at his office and was told to wait in a conference room. And as he did, there were files in there where they were looking over the case. He went in, opened up the file, took pictures, these pictures right here, the crime scene pictures of it, and then released them to somebody else. And luckily they weren't put out, thank God. People had
they were never sent out to the public for public viewing.
Well, they were sent to YouTube creators and something else, and then one person actually took his own life over this scenario, okay, which is strange, but I guess I understand the scenario behind it. But they were never, to me, it seems as if that person was paid or asked to do this for whatever reason, okay? And that's the reason why Judge Gull decided to remove them from the defense, because she said that they're not, basically in layman's terms, trustworthy to be able to defend this guy. So it was a whole thing. And like I said, it seems
that's where the judge went after. But they filed charges against the guy, police reports. I mean, as lawyers, they did the right thing when they realized that stuff had been taken by that man.
Yes, sir. Yeah. Oh, yeah. They handled everything.
That's what always offended me with the judge.
Right.
That offended me. They did the right thing. And you, no matter how much you want to think or conspiracize in your head that they didn't, that's no basis to make a ruling. Okay.
Agreed.
Your errant thoughts are not relevant. The facts of the case show that these guys did not participate.
And that's Teresa. She said, I believe the prosecution was behind the leak, and of course, there's no way to prove that. But I've seen a lot of people say the same thing, and it makes sense. The gentleman that did it was the Mitchell Westerman, and I guess he's going to go to trial for that as well. But was he
connected to the state or the prosecution?
He worked for the defense attorney at one point, Baldwin, and they were friends or whatever. And it was weird because he hadn't seen him in quite a while. And all of a sudden he just pops up to say, hi, you want to have lunch? You want to have coffee? Whatever. And as he's waiting, because of course the attorney was busy at that moment, that's what he did. They had their interaction and then he left. And next thing you know, these photos were sent to that team of husband and wife or boyfriend, girlfriend, I think they are. they're YouTube creators. They were sent to them and somebody else, I can't believe, through another
You know,
person.
what's the name of their stream?
Oh shit. It's you would ask me. I don't watch them regularly.
Of course I would ask you.
I'm not fans of theirs. What the hell is the name? Does anybody know the name of that? Shit. It's
two young people? Dark hair?
Oh, the woman's younger. He's probably about 45, I would guess, or maybe he looks that age.
I don't know. I'm thinking of someone else.
It's not a regular. Yeah, it's a podcast.
He's a lawyer. So is she.
I think so. I can't think of their damn name right now. What the hell is it?
It's his personal name or something as part of the stream. I forget it.
Murder Sheet. That's it. It's called the Murder Sheet. Thank you, Julie. That's it.
Murder Sheet?
Yeah, here, I'll show you real quick.
Yeah, if you kind of like to see who it is.
Yeah, they sent him to them. They, in turn, got a hold of authorities and attorneys and said, hey, this happened. And, you know, they didn't put him out. They were smart enough to. Let me find him here.
So it sounds like this guy did it for his own tickles. I mean, if what he did was take these documents and then send them to a streamer, unless there's a connection between the streamer and him, this guy just took it upon himself to release information.
Mm-hmm.
Right? Doesn't
sound like I said, it almost, a lot of people are saying they feel like the prosecution and it makes sense. You know, it makes sense.
But there's nothing to support it at this point. His actions speak for themselves unless somebody can draw a direct connection through phone calls or emails or something that he was connected to someone to inspire his act.
Oh,
or he makes that argument in court. Otherwise, I don't suspect the prosecutor's involvement. People do some shit, man. You just don't know.
It could have been made to look that way too. You know what I'm saying? So I mean, there's a lot of different variations of it. These are the two right here.
Yeah.
Not right. Bashley over here, but these two here.
Oh, I've never seen them two, to be honest.
I don't think they're husband, wife, or boyfriend, girlfriend.
No, that guy freaks me out. What's up with that?
Yeah, he's a little.
Yeah.
One of the people involved in leaking the scenario unalived himself. So it started with one, then it went to another, and then it got to them, and then so on and so forth. So yeah.
Is their show any good?
It depends on what you like. You know, I'm not going to downgrade them. I'm not going to talk down about them. It just depends on what you like and what you look for when you go on here. You know what I mean? Yeah, that's my thought too. It was very much too coincidental. That's all I'm saying. I agree with you on that, Stump. But what are you going to do? And it led to this whole breakdown of what's happened recently too. If that would have never happened, none of this other stuff would have happened, I don't think.
Well, you know what the irony in all of this is, just so you know, there's no way the prosecution could know that these files were in his office, available for someone that got access to the office to just grab them. Right?
No, but there's a way that the guy that did this could have known where they might be because he worked there.
Well,
you know what I'm saying?
But again, we were told that he came in out of the blue. He's a friend from a while back, came in for lunch. Seems like it was a jump opportunity. The opportunity presented itself, and this guy just took it.
Yeah. CL, the actual photos of the girls were leaked.
Yeah, that's terrible.
And it was horrific. And I was like, please don't put these out. Don't put these out. Don't put these out. You know what I mean? And thank God these guys didn't, and nobody else did either. I don't believe anybody got a hold to put them out, but you don't do that. You just don't. We don't need to see that stuff to be able to make our
see,
you know what I mean?
I just want to respond. I'm being told that I don't know that, Sarge. Well, I don't know it, but I think it's a fair assemblage of the information we have. That this man that showed up, that hadn't been around for a while, was in the office. That lawyer had to get up and go do something. And while that lawyer did, this guy took it upon himself to look at the files that were open or available, and he stole photos. I think that you can make that argument very plainly. I think that's what it's going to say in the police report. Now, for us to say that the prosecution sent him in there for a plan, we need more information. Because that scenario of events doesn't suggest anything more than he took a chance. Because there'd be no way for the prosecution to know this lawyer had these files open and available for this guy. You know what I mean? The variables are just too significant here. So, yeah, you could want to think that the prosecution did that you can consider that. I'm not saying it's unconsiderable, but the information we have as of now doesn't show any prosecutorial involvement.
Mm-hmm. Thank you, Noni, very much. And Doodle, thank you as well. They just sent me some stuff.
Oh.
Noni sent me some stuff about this, and
I don't think I've ever been around when I've seen Noni in here before. Have I ever talked to them?
Oh yeah, she's always in here. Noni McPoppin, she's been here for a long time, actually.
Oh,
you just don't pay
always...
attention.
No, maybe it's because her name is in green that I notice her now.
I don't know. She's been in green for a long time.
Oh, okay. My bad. Shame
good.
on the Sarge.
It's okay.
Don't you judge me.
Never, never. Does anybody else have any questions, thoughts, theories, opinions, statements you want to put out in regards to this? And like I said, fingers crossed, we'll get, I'm pretty sure I'm going to be live tonight, you guys, as well. So if you're bored, come on back in.
And I'm going to step away. I'm grateful you brought me up here. I appreciate the time to air. And
I appreciate your opinion.
I'm going to go make my sausages that are going to be eaten off a Hamburg bun.
I'm not saying a word. Not saying a word.
No, I it's fun. Listen. When you go to a store to buy, remember the traditional Hamburg buns and hot dog buns we've been raised with?
Yes.
They're like, okay, there's 8 per pack, right?
Yeah.
Well, I'm a single guy. So I buy a pack. I've got sausages and I've got hamburgers. So what do? Do I buy a pack of each? What am I going to do with 16 rolls? They're going to go bad before I'm finished with them, right? So what I do is I'm going to have hamburgers, and I had hamburgers first, so I bought the hamburgers. So now I'll make the sausage fit the hamburger rolls.
I know, I get it. I've eaten hot dogs off hamburger buns. I don't know how many times.
Oh yeah, man. You got to work this stuff out. I'm not going to throw money away on 16 buns that I'll never eat 16 over the course of a month.
Right. No, I get it. I absolutely get it. You can't waste. You can't waste what you don't have and all that good stuff. So I do it all the time. See, I'll ask a question up here. Who was the guy that leaked them? No charges. Was it he? He used to work for one of Richard Allen's original attorneys, Attorney Baldwin. He was I believe he was a consultant with the firm at one point. So he didn't no longer work there, came by to say, hey, did that conveniently and moved on. And he has been charged. He's going to court over this. So,
yep. All right. Thanks, Dig. I'll talk with you again, buddy.
Yes, sir, brother. Thank you very much for your input. As always, much appreciated. I hope you have a great rest of your day. And if you're bored later, stop by.
All right. Thank you.
Take care. Thank you very much, Sarge. I agree with you, Josie. I hope that he does get his attorneys back. And again, thank you for that, Noni. I will be looking through that. We don't fake photos here. Blah, blah, blah. Yeah, for sure. Definitely. That's pretty interesting. Thank you, Noni. Very much appreciated. Any other questions from anybody about this or no? I thought the hearing was going to be a little bit longer than it was, but I guess we got what we needed when we needed it. You know what I mean? So again, I want to thank you guys for being respectful towards the moderators. Well, thank you, SRB. I appreciate that very much. Again, anybody that, because I haven't even looked or listened or tried to pay attention, but anybody that may have donated to any one of these links to support the channel, again, folks, that does pay the bills. That keeps my internet running, my YouTube going, and all that fun stuff, StreamYards, everything. I appreciate that because that's where that goes, guys. Anybody that may have donated to that in support of that, God bless. I really do appreciate it because it more than helps. And it's definitely not expected, folks, but I am beyond appreciative. Thank you for that. And thank you, SRB, for posting that. Teresa, I don't see anybody having any questions here. David Clayton says, I still believe that Keegan Klein had some involvement. I mean, he's definitely a sick person. I agree with that, David. And his father, again, another sick person, in my opinion. So I can go along with that. Let me see here. Thank you, Michael Bell, 007. I appreciate that. And again, Sarge, thanks for your input on this. I always appreciate it. As I do anybody's that has any input on any of the cases we cover. Yeah, Tony, Keegan Klein, absolutely, David. Vile. I do agree with you. They are some disgusting people, folks. Keegan Klein, there was a lot of child pornography found in regards to him, like really nasty stuff, folks. Just disgusting. These people make me sick. No worries, Mrs. Krampus. I appreciate you being here. Thank you so much. Natalie B. I appreciate that. Today is about Delphi, though, so I'm not going to jump from one to the other like that. I just won't do it. But thank you, Natalie. I appreciate that. I'll have to go check it out myself. Yes. Miss Krampus said, just sending love and appreciation to Doodlebug for the boots on the ground. And we do very much appreciate you, Doodle, for doing the things that you do here and for doing that mostly. Like I said yesterday, you're a hero in my book, and God bless for doing that. As I said, folks, I'll be following that investigation into the Donna I case because I'm not comfortable with the situation, guys. Something is wrong, and I don't like it. David Clayton, a member for 6 months. That's awesome, David. It's wonderful to have you in the sauce with us and having you as a meatball, my friend. Appreciate you very much. You're right, just like you did, Mrs. Krampus, just by saying it and being here, knowing that you're here is all that matters to me. I appreciate you very, very much. Yes, thank you, Victoria. The mods in here are amazing, absolutely amazing. Again, guys, if you would please keep Miss Wisdom Speaks in your thoughts. She's been sick and she's got that crappy virus again. So just say a little prayer for her and keep her in your thoughts, folks, because it's a dangerous thing out there, and I worry about her, as I do anybody that may come up with that. So all the other mods, Doodlebug and everybody else in here, Brady B, SRB, thank you all so very much for doing what you do. I couldn't do this without you. Teresa's been a member for 4 months. That's awesome, Teresa. Congrats. Thank you for being here and being part of this community. We love and appreciate you very, very much. Doodle says, oh, you're all welcome, but I just wanted her found. She's found and her family can try to grieve and try to move forward. Amen to that one, Doodle. And again, thank you for being who you are, Doodlebug. We love you so very much. Yes, agreed. Noni, she is a hero. I agree with you on that. I wish the outcome would have been different as well. I was really hoping, folks, that somebody picked her up and she was somewhere else safe and sound. I was praying for that, and unfortunately that wasn't the outcome. So hopefully there's something that's found on this to make some kind of justice possible. Again, Michael, a member for 5 months. Congrats, Michael. That's awesome. And we, again, wonderful having you in this community, sir. I appreciate you very much. Thank you, Sony. Appreciate you very much. Miss Kells, that's right. Prayers up. And again, guys, if you will, please just keep Donna's family and Donna herself in your thoughts and prayers. You know, every now and again, just take a little extra thought about them throughout the day if you can, hoping that they're getting through what they're going through in the very best way possible. Of course you would, Doodle, because that's the person you are. You are appreciated for that. Everybody appreciates you too. Not a lot of people would take the time to go do that, Doodle. You have to understand that. That's why people are responding to you that way. Not a lot of people have the ability to go do something like that, for one. And two, not a lot of people would take extra time out of their own day to go help somebody else in that form. That's why I think everybody feels the way they do. That's why I feel like I do towards you. I mean, I would have done it too if I had the ability to, but you did it, and that's what matters. So thank you so much for that, and God bless. Sherry, and yeah, and that was cold that day too. It wasn't like it was 75 degrees outside. That was another thing. That's why she did it, guys, because that woman was out in the cold and possibly still out in the cold, and she wanted her home. End of story. So again, thank you. I don't see anything else in here. But I just wanted to say to every one of you guys, separately and together, I do absolutely appreciate every one of you guys for being here, for supporting the channel the way that you do, and for supporting each other the way you do. You guys are amazing. This community is so very, very, very amazing. And I adore every one of you guys, and I appreciate you all so very much. So with that being said, guys, like I said, there's a big possibility I'll be here tonight too. Just look for it. I'll throw it up early enough, and you guys will know. But don't forget, guys, to love yourselves, to love each other, and don't change a thing about yourselves, because you all are the beautiful people. Have a great rest of your day, folks. Much love to you all, and I will see you soon. Bye-bye.